And thank you for joining this webinar. I hope you find it informative. Today, as the title indicates, and why you signed up for this, we will be talking about insolvency and the cannabis industry and emerging issues that we see, and alternatives to bankruptcy. Before we start, a little bit about me and our firm, SulmeyerKupetz. I've been a partner at the firm essentially, and have been at the firm since I graduated law school in 1994. So I've been here for 25 years, and at a firm which is a boutique law firm in downtown Los Angeles that has been for the past nearly 70 years a firm with a focus which has been and continues to be on bankruptcy matters, liquidations, reorganizations, related transactions, and litigation. We have two of my partners are panel trustees that serve both as Chapter 7 and 11 trustees. So some of our practice involves representing those folks, and that discussion of trustees will be included in this presentation. As a bankruptcy lawyer for over 2 decades, people sometimes ask me what I like about being a bankruptcy lawyer. And I think one of the things that I like most about being in this profession is that as bankruptcy lawyers, we gain by necessity experience in a wide variety of legal matters. And we see our focus change, and we need to adapt depending on what's going on in the world, our country, and our economy. For example, over the course of my tenure at the firm, we've seen 2 major real estate downturns, one in the mid-90s and one, again, after the Great Recession. So during that time period, as lawyers, and the influx of cases that came into us were based in real estate matters. So we had to become experts in valuation, in sales and transactions, in lending, and in interest rates that would be appropriate under plans of reorganization. We also had an issue in the early 2000s when the tech bubble burst, and we had to adapt and learn IP issues and learn about how to represent clients in assignments for the benefit of creditors, which had been, again, something that we'll talk about a little bit later, which would have been a procedure that had been sort of long forgotten and came back into the forefront during that dot bomb era. Now we're seeing retail, brick and mortar cases are being decimated by the online shopping trends. So we've needed to become knowledgeable and adept at dealing with leasing issues, inventory, finance, and related issues in those retail cases. So it's with this need to adapt to various different areas of law that has gotten me intrigued in the cannabis industry and its recent trend towards legalization. This is new law. It's complex, and it presents interesting issues that really center around the juxtaposition of state laws versus the federal laws. And in an industry that is experiencing such staggering and widely known growth, with a lot of money being invested in it by entrepreneurs, investors, athletes, celebrities, we believe that insolvency practitioners and those that advise companies in this space whether they be advisors to investors, lenders, or vendors, should be prepared to deal with the distress situations that are likely to be encountered. So what this presentation will cover, we'll go through the slides, is a general discussion of the legal landscape in the cannabis and cannabis-related industries, the reasons that cannabis businesses may experience distress, find themselves in need of a bankruptcy or similar insolvency type proceeding. We'll go through whether the bankruptcy doors are open to such businesses or businesses that do business with cannabis businesses. And in doing that, we'll look at some of the current case law that has been coming out of the bankruptcy courts and appellate courts on the issues. We'll discuss issues in representing a cannabis client that wants to file bankruptcy or a creditor of a cannabis business that is seeking to collect on its judgment through a bankruptcy or insolvency proceedings. And finally, if bankruptcy is not an alternative that's readily available, and you'll see through the presentation, spoiler alert, it is not. We will talk about the alternatives that are available. So just briefly, who will benefit from this webinar? Basically, looking at the roster of all of you, and there are a lot of people that signed up. There's a lot of interest in this webinar. Are professionals that are advising clients in the cannabis space, whether it be attorneys, financial advisors, restructuring officers, accountants, or those that are interested in investing in the industry, doing business with those in the industry, or lending to the industry. Just by way of background to focus our attention, just to go through some of the cannabis industry statistics. As we all know, cannabis sale, cultivation has become legal in many states. So currently, it's legal or decriminalized, meaning that the states are not prosecuting violations of any cannabis laws in 38 states. 10 states, including California, of course, and the District of Columbia, have fully legalized recreational and medicinal sale and use and cultivation of marijuana. 15 states have decriminalized recreational use, in addition to those that have made it fully legal. And in those states, some of them limit the decriminalization to certain cities or counties. And I find these numbers to be quite impressive and staggering. The total domestic retail sales in 2019, this year, are projected to exceed $12 billion. To put that in perspective, I believe that statistics are that Americans are spending more money on pot than they are on McDonald's. And it makes it one of the fastest growing and one of the largest industries in the United States. There are predictions by some that the sales will reach over $25 billion by 2003. With those sales comes a significant amount of tax revenue. In 2018, the estimates are that California itself pulled in $300 million in tax revenue, with some estimates projecting that just recreational taxes alone will amount to more than $1 billion in California. So this is very lucrative for the state, and is likely one of the reasons why there's such mass support for its legalization amongst the legislators and the people. So with a robust industry like this, you find a lot of folks that want to get into it and take advantage of the perceived profitability of the industry. So you might say, well, there shouldn't be distress situations with such a widely growing business and fast growing business, but that's simply not the case. Just because there's growth in an industry doesn't mean it's immune from problems that may lead to the need for an insolvency or distress situation. One of the most challenging things, and one we couldn't go into much detail on, you could do an entire program on it, is the difficult, expensive, and complicated regulatory compliance. There are multiple levels of applications at the state and local levels, and reporting requirements by marijuana businesses that simply some smaller operators simply just cannot navigate their way through in a way that makes economic sense. And in fact, while this is not an endorsement of a particular series, there's an interesting documentary on Netflix called Murder Mountain, in which they discuss the marijuana trade in Humboldt County, which has traditionally been a black market and is now going to the legalization. And the smaller farmers are finding it impossible to make any money to do it legally, and are continuing to choose to operate on the illegal side. There's one of the issues is heavy sales and property taxes. You'll see these numbers. California cultivators pay $9.25 per ounce on flowers and $2.75 on leaves. Retailers on recreational use are paying an excise tax of 15%, and then local authorities also tax the businesses as well. So, for example, in Santa Ana, they recently passed a measure. Santa Ana has a lot of green zone businesses. They passed a measure authorizing a tax based on the gross square footage of the business, or up to 10% of its revenue. There's also the issue of federal income taxation in a sort of hypocritical way, even though the marijuana sale and cultivation, marijuana businesses are illegal at the federal level, which we'll get into in much more detail below. They still expect you to pay your income taxes. And under the Internal Revenue Code, a marijuana business is not able to deduct anything other than its direct cost of goods sold from its gross income. So operating expenses are not a business deduction. So these businesses that choose to file tax returns and do so appropriately are paying income tax to the federal government at a much higher rate than a quote-unquote legitimate business. There's also market fluctuation in the price of the product for the farmers that they can get. At the high level in 2015 or 2016, farmers were getting approximately $2,000 a pound for premium product, and that has dropped. It dropped down to about $1,000 a pound for that product, and some of that fluctuation is put on the fact that there are large commercial operations going in, squeezing out smaller farmers. And while there's been a current uptick in the price, it remains significantly below below the high values, pun intended, of the product. And so this is very much a commodity business, and with fluctuations like that, it becomes difficult to maintain operations and clearly could lead to a distress situation. Another biggie, and one that has been discussed a lot, is the lack of the ability to bank the revenues that these businesses receive. Traditional banks are not accepting deposits of cash from marijuana businesses. They're federally chartered. They are federally insured, and while they may start accepting a business's cash, once they determine through due diligence that they are required to do that you are in that a business is in the cannabis space and its deposits are coming from sales of cannabis, they will move you out. And so these businesses have remained, in large respect, cash businesses handling millions of dollars in cash, with that cash going into vaults with armored cars. There's co-ops, and there are cottage industries now with smaller banks and online institutions that are finding their way around the problem and helping these folks bank their cash, but they take fees. It's expensive, and it causes issues with all kinds of things, including their accounting and financial controls. Likewise, similar to the inability to bank, there's lack of access to any traditional lending sources. A business that is interested in financing its operations cannot go down to their banker at Chase or B of A or Wells Fargo and ask for a loan because they will be denied. And in fact, many lenders on the institutional side are requiring borrowers to execute riders in which they covenant that they will not engage in any marijuana business or cannabis business. There's cannabis business riders that are being attached to many loan documents now. So these businesses are now resorting to non-traditional sources, private equity, family office, or hard money lenders. And while the cost of those loans has come down, it's still very expensive. Something that's another potential, and this is sort of very recent, we could see a potential for marijuana businesses in the vaping industry facing liability for the new trend of interest and concern with vaping-related injuries, all seemingly coming from the marijuana vaping. So to the extent that these folks get sued, that's a traditional trigger for needing to end up in a bankruptcy. And for the reasons we'll discuss later, they may have a hard time with that. Other issues that are triggers for the need for an insolvency or distress situation, dispute between partners and mismanagement, the lack of financial controls, given the inability to bank in a traditional manner, the difficulty with accounting, the difficulty with payroll. All of these things are sort of fodder for problems with the management of their cash, and give accountants and financial advisors a lot of gray hair. And finally, and this is a major issue, given that the sale and cultivation of marijuana remains a violation of the federal law, which we'll get into the specifics of in a moment, though the businesses that are in violation of the law are subject to Civil Asset Forfeiture Act, meaning that the government can basically come in and seize all of the assets of a business found to be trafficking in marijuana. Now, the law is not currently being enforced. Going back to the Obama administration, when something called the Cole Amendment was, or the Cole Memorandum was issued by the then Attorney General, that directed the Attorney Generals in the United States and under the Department of Justice to not enforce the Controlled Substances Act against businesses that were operating legally by state law. Jeff Sessions, while he was with the Trump administration, rescinded that memo. Since then, there's also been amendments put up in Congress that have passed, the Rohrabacher Amendment, under which it was a budgetary thing where Congress said the DOJ may not use funds to prosecute marijuana businesses doing business legally within their states and according to their state laws. But the fact remains that it really is a tenuous situation, and that the enforcement under the federal government, by the federal government, could change based on the whims of Washington. And while billions of dollars are going into this industry, people are taking a calculated risk that things will not change and that the federal government will continue to take a hands-off approach on this robust industry. So what is the law? The law that makes marijuana sale, use, and distribution illegal in the United States under federal law is the Controlled Substances Act. Without getting into too much detail on that, it places the drugs into 5 schedules based on their danger, perceived danger, potential for abuse, and balanced against any accepted medical use. And the Schedule 1 drugs are determined to be the most dangerous, with the highest risk of addiction and no recognized medical benefits. And marijuana is placed within Schedule 1 along with heroin, peyote, ecstasy, and LSD. And as you know, there are harsh penalties, even for the mere possession of marijuana. Criminal penalties can be up to $2 million and 20 years in prison for trafficking and up to 1 year for simple possession of marijuana. And as we get closer to covering the topic of the day, with the bankruptcy intersect into on this issue, the United States Supreme Court in Gonzalez v. Reich has held that under the Commerce Clause, Congress has the authority to ban the cultivation, use, and possession of marijuana, notwithstanding the California law, which at the time was decided under the medical marijuana laws before Prop 64. And California case appellate courts have continued to hold that the Controlled Substances Act actually preempts California medical marijuana laws. So the question becomes that's asked and speculated on widely is, will this law change anytime soon at the federal level? And all or almost all of the 2020 Democratic presidential candidates support either legalization of cannabis on a federal level, or leaving it up to the states to decide, which is interesting because that is a traditionally conservative approach of allowing the states to decide, but it's been championed by the Democrats. There's measures in Congress that have been put up by various senators and Congress people to legalize marijuana or decriminalize it. And currently, Senator Mitch McConnell, the majority leader, has taken a position publicly that he will never let any legalization measure make it to the floor. However, many pundits on the issue, people you talk to, read articles about, are predicting that based on the size of the industry, based on the need to regulate the products that are being sold in the states for strength, purity, danger, etc., that the government will have sort of no choice but to ultimately bring federal legalization around in some form or fashion, and that based on that, legalization is a real possibility in the near future. And if that happens, then a lot of this presentation will become moot. But in the current landscape, it remains illegal with no immediate prospect of its changing. So, getting to the meat of today's presentation, can a cannabis or cannabis-related company file bankruptcy? And the short answer is no, not really. They will undoubtedly face a motion to dismiss the case, whether by the United States trustee or otherwise. And the case trend is where there is marijuana associated with the debtor and the debtor's operation, the case will ultimately likely be dismissed. And it's really important to know that the United States Trustee's Office's policy on this issue. While, as we talked about before, there's a prohibition of the DOJ from taking enforcement actions against legally operated cannabis businesses, the exception seems to be that the United States Trustee has a clear directive to its panel trustees and to its district trustees that its policy is to seek dismissal of any bankruptcy case where marijuana-related assets are involved. And the policy is clearly laid out and explained by in an American Bankruptcy Institute ABI article by Mr. Clifford White, who's the director of the executive offices for the United States Trustee, in an article written "Why Marijuana Assets May Not Be Administered in Bankruptcy." And while that was originally printed in the ABI, it's been reprinted at www.justice.gov, and there's a link to the download of the public document in the web in the PowerPoint. But their position is centered on two basic principles. First, the bankruptcy system may not be used as an instrument in the ongoing commission of a crime, and a reorganization plan or plans that permit or required continued illegal activity may not be confirmed. Second principle is that bankruptcy trustees and other estate fiduciaries should not be required to administer assets if doing so would cause them to violate federal criminal law. That was issued in an article in 2017, and Mr. White's the same principle was repeated in a letter from Mr. White to Chapter 7 and Chapter 13 trustees, and that's in your materials. Essentially, the United States trustee has clearly instructed all of the panel trustees that operate under their supervision, the Chapter 7 and Chapter 13 trustees, and while he doesn't mention it, I would assume this would extend to Chapter 11 trustees that are appointed, that in the event that they suspect that there is cannabis assets involved in a bankruptcy case in which they've been appointed, that they are directed to immediately advise the United States Trustee's Office for their district so that the U.S. trustee may move to dismiss the case. So what's the current case law? Not surprising that given the novelty of the law, the novelty of the issues presented by the divergence of state and federal law, the growth in the industry, and the issues that we've covered before, the operational issues and legal issues that cause businesses to fail, there have been a number of reported decisions on the issue that have been published, both by bankruptcy courts and appellate courts. And I think a really excellent case for educational purposes, really for us as practitioners, is found in a decision of In re CW Nevada, and it's written by Judge Nakagawa from Nevada. And this was recent. It was within the last 5 months. And the reason I found this article to be quite interesting, or not article, but decision to be quite interesting, is that the judge surveys the current significant reported decisions post-legalization of marijuana. And he goes through and discusses the issues presented in Chapter 7, Chapter 11, and Chapter 13 cases. In the Chapter 7 context, which is the context where a trustee is put in to liquidate assets, the common theme in the cases is that those cases will be dismissed because the trustee, a fiduciary, and an agent acting under the Department of Justice cannot administer assets, because to do so would be a violation and create a federal crime. So it's not sufficient for the trustee to abandon the asset, as he may do in a situation where he encounters environmental issues or an overly burdensome asset that he can't afford to operate. The case must be dismissed, and cases involving Chapter 7 and cannabis industries are finding themselves getting dismissed. In Chapter 13, which is a case in which an individual is seeking to discharge assets through an individual plan, there appears in the cases to be some flexibility to allow a debtor to confirm a Chapter 13 plan if the plan is to be funded by non-cannabis related income. In one case, the bankruptcy court, in its decision, gave the debtor a chance to prove that he was ceasing all marijuana related businesses as a condition of staying in bankruptcy. But ultimately, if the court finds that a plan of a Chapter 13 debtor is dependent in any way on cannabis income, cannabis-related income, then the case will get dismissed and confirmation will not be approved. And then The one that we're probably all more particularly concerned with is Chapter 11 in corporate or individual reorganizations that exceed the Chapter 13 debt limits. The issue really becomes, can a debtor confirm a feasible plan of reorganization that doesn't violate the law and can be funded by income that's derived on anything other than assets and income from the violation of the Controlled Substances Act. And you see that most of the cases find that they cannot, and the cases are being dismissed. But there was the recent case of Garvin v. Cook Investments by the Ninth Circuit, decided only 4 or 5 months ago, that some are touting as an indication that there might be some glimmer of hope to cannabis-related businesses to enter into and confirm plans. In that case, it involves the confirmation of a plan by a debtor who was not in the business of selling or cultivating marijuana, but had leased a portion of its property to a licensed marijuana business. The United States trustee filed a motion to dismiss the case based on gross mismanagement, and the court denied the motion based on the representation by the debtor that it would file an amended plan of reorganization that would reject the lease to the marijuana business tenant and seek to displace that tenant. And that new plan and the rejection of the lease was confirmed and upheld on appeal. In upholding that, the confirmation, the Ninth Circuit adopted a narrow interpretation of the rule that a plan can't be proposed by any means forbidden by law. And the argument was a marijuana business is a business that is forbidden by law, but the court found that no, what 1129 requires is that you're simply not proposing the means by which you're proposing the plan and are not violative of the law, are not forbidden by law, not the substance of the business itself. As to the motion to dismiss based on gross mismanagement, the Ninth Circuit ruled that the U.S. trustee procedurally had screwed up and had not renewed its motion after it was initially denied by the bankruptcy court. So the question is, does Garvin really open the bankruptcy court's doors to marijuana businesses? And I think that the answer is no. People are reading far too much into this narrow interpretation of a specific provision of the code. Remember, in that case, the debtor was talking about proposing a plan that eliminated the marijuana business from its facility. So it was going to be confirmed based on non-marijuana related income. But courts, considering this decision, are not going to be guided by Garvin v. Cook when considering an early motion to dismiss the case based on gross mismanagement. Because of the waiver by the United States trustee of its motion to dismiss, the court really didn't get to that issue. And so we believe that had the U.S. trustee acted procedurally properly and followed and renewed its motion, the results would have likely been very different. And you can probably count on the fact that the U.S. trustee is not going to get it wrong the next time. In fact, cases both inside and outside of the Ninth Circuit have continued to dismiss cases and declined to give Garvin v. Cook this weight beyond what the specific case said, and are dismissing cases at early stages based on the gross mismanagement standard. And in fact, while the case in the materials is Barish versus Custom Design, the CW Nevada case, which I encourage you to read, also reached the same conclusion and provided that the Garvin v. Cook case did not guide it on the issue of dismissal for gross mismanagement based on a business that continued to operate in violation of the federal laws. In addition to the practical impediments or in addition to the legal impediments that we just covered in the case law of a cannabis business going into bankruptcy, there are some just practical considerations which I think would prevent a company from effectively going into business even if the case law has changed. The inability to bank with federally chartered banks that we covered earlier. The United States trustee requires that in any Chapter 11 case, the business shut all of its pre-petition bank accounts, and all cash needs to be banked with an approved depository, all of which are federally chartered, and none of which would theoretically accept cannabis deposits. So without the ability to open a debtor in possession account, there's no Chapter 11 case because the case will get dismissed. Again, inability to obtain debtor in possession financing from traditional sources to the extent that the debtor needs it would be an impediment to the case. Plan feasibility issues. Can a debtor who relies on marijuana income prove, and can a judge rely on that income, that it would have that income in the future in the face of uncertain laws and the legal landscape that we've covered before? This is just a practical consideration for those of us that are debtors, lawyers. You need to disclose, professionals need to disclose the source of their retainer. And if the source of the retainer is marijuana proceeds from a marijuana business, question that you have to consider is whether you now have a problem of your own. You disclose where you got the money, and the money is from a federally illegal business. So with bankruptcy as likely off limits for the near future, people look for alternatives. And one of the alternatives that has been utilized, particularly by creditors and lenders that find that their customers are violating their marijuana policies and growing or selling marijuana on properties that are their collateral, is a receivership. And while the cases that we see are mainly brought by lenders, and that's the general rule of a receivership, is those cases are receivers are sought by creditors or lenders. I don't see it being unlikely or impossible that in face of partnership disputes or creditor disputes that a cannabis business could stipulate to the appointment of a receiver to oversee the liquidation, sale, or even restructuring in some fashion of a cannabis business. And so people have been employing that. And what are the issues with it? One of the issues we'll find is that only a few states have laws specifically addressing and authorizing a receiver to take possession of and administer cannabis assets. You have laws on the books in Colorado, Oklahoma, and Oregon. But we know that lenders and receivers are being appointed in California, and that the way that you get around the fact that there are no specific laws on the books in California is that the parties requesting the appointment of a receiver are very careful in the drafting of their receivership orders. And in those receivership orders, they're specifically laying out the fact that the receiver steps into the shoes of the licensee and may administer the assets. So that is what's going on. There are a number of receivers in California. You can look it up on the internet that are specializing in marijuana and cannabis related businesses. What are the downsides of a receivership? Again, as we just said, the receivers typically work for the interest of the creditors, but not the businesses. But in a receivership, everything is in the order. And if it was a consensual process involving the debtor and debtor's management, there's no reason that a receivership order could be drafted in a way where the rights of equity are included under the authority of the receiver or the obligations of the receiver. In states with undeveloped laws regarding receivership in cannabis space, the inexperienced state courts may provide unpredictable results to you, so you might waste your time in seeking to get a receiver, or you might not get the results that you want. And finally, it's expensive, but that's sort of a wash to me because everything involving insolvency turns out to be expensive. So I'm not sure that I could say that a receivership is more expensive than a bankruptcy proceeding, to the extent that you could operate within one. So another alternative that's been asked of us, since our firm has done many assignments for benefit of creditors over the years, again dating sort of back to the bomb era, is would an assignment for the benefit of creditors be a viable alternative to a company that was seeking to, a cannabis company that was seeking to liquidate its assets? And well, first, what's an ABC? An ABC is a state recognized by a majority of the states in the country, including California. It's a state recognized vehicle for an out-of-court liquidation of assets of a company. The high level of what that is that the company, the debtor, assigns all of its assets to a fiduciary called the assignee. The assignee then generally will liquidate the assets either in whole or in part, and distribute the proceeds in accordance with the priorities of that state, which generally but not exactly follow the bankruptcy priorities of distribution. The benefits of an ABC are that the debtor picks the assignee. It's someone he interviews, sometimes with consultation with creditors to the extent that a secured creditor is involved. The other main benefit of an ABC is that it is a very effective way of operating a business and taking possession and selling assets, because there's no bureaucracy involved and no court proceeding involved, and there's no court supervision. So an assignee doesn't have to file a motion to have authority to do anything, including the sale of the assets. The downside of an ABC is there's no court supervision. So while it's an upside, it's also a downside. Without court supervision, there's no court orders, there's no comfort orders, there's no order authorizing a sale of an asset free and clear of liens. So you need to get secured creditor consent. And sometimes that sale in an ABC to a third party is not as safe as having that 363 sale order. There's also no ability to assume and assign leases or executory contracts without consent of the other party. The concern I have in answering the question of whether an ABC is available to the marijuana context is, without the benefit of going to the court and getting an order authorizing the assignee to administer assets and operate a marijuana business, you're asking the assignee to take on a major risk that he's violating state and local laws, because generally those assignments are the licenses that the business have are not assignable. So what we can do, what the potential fix, although it seems cumbersome, is the assignee pre-acceptance of an assignment could go to local authorities and all the licensing authorities and see if they could get consent. But to me, that seems like a very big hurdle, and I don't consider an ABC to be a valid alternative unless, and someone suggested, although I'm not familiar with anybody that falls in this boat, an assignee who has his own state or local license to operate a marijuana business could possibly take over the assignor's business, operate it, and sell it. So on this final slide, and we're running close to the end, just some legal issues of representing cannabis clients as we navigate through this sort of new law and new area of law. In California, the state bar has stated that it's permissible for a member of the bar to advise a client about compliance with California's marijuana laws, but that member may not advise the client to violate federal law or to assist the client in violating federal law in a manner that would enable the client to evade arrest or prosecution for violation of federal law. So that's interesting. The state bar says you can advise a marijuana client about following California laws, but you can't advise a client about violating federal laws, and the California law violates federal law. So that's an interesting situation. And if you do take on a representation of a marijuana client, you are required, and I'd suggest you're required to do it in your retainer agreement, that the marijuana activities sale are a violation, continue to be a violation of federal law, and you must advise the client of the potential consequences and penalties associated with the violation of, if prosecuted. And as we said before, those prosecutions, while not currently being made, the penalties are very severe. And I was recently asked by someone whether if I would file a bankruptcy case for a marijuana business simply for the purpose of obtaining a stay, as people are known to do. And my response to that was, or my thought and my concern with that is, if a lawyer filed a case that you know is likely to be dismissed because the cases say a cannabis business cannot be a debtor, are you somehow exposing yourself to potential sanctions for filing some kind of a bad faith case or Rule 11 sanctions? None of the cases that I've read that have been published, and I think I tried to cover all of them, involved sanctions being awarded or even considered against filing counsel. And that may be because these cases are so novel. But as the cases solidify into the positions that we're seeing where the eligibility is highly in doubt, I would have a concern at my firm. I'm conservative. That's my approach to things. And I think it's a risk that you need to know you're taking. And a final legal concern that I would raise is, one of the things that we talked about is it's illegal under the CSA Controlled Substances Act for your client, for a person to lease its property to a cannabis business. That's still a violation of federal law. And as we get clients in the door that you may not suspect to be involved in the cannabis business, but maybe commercial property owners, I think it's now incumbent upon all of us as practitioners to find out whether any of the tenants on the property are in the cannabis industry, because it could affect and will affect the bankruptcy case. And in fact, it happened to me early on during the early days of legalization of marijuana on the medicinal basis. I had a client who had a number of small parcels of real property. From the name of the tenants, which were all individuals, I had no reason to know what they did on the property. And during the 341A meeting, we found out that one of the tenants may have been operating a marijuana growing facility within one of the locations. We then confirmed, at the direction of the United States trustee, that our suspicion was not correct. There was no growing going on in the facility, but it was a dicey few moments in the case. So I think it behooves us all now during our client intake, to really know what all of the tenants of our potential clients do on our client's property. So that's the end of the presentation. I am happy to answer any questions that can be emailed to me through this webinar, and to the extent questions have been asked during the webinar, we will answer them in due course. You will be receiving your MCLE certificates from Burbay shortly today. Confirm that those will go out today, and I appreciate your participation, and I hope you found this helpful.